All right, let's proceed. Thank you.
Good morning, Your Honors. My name is Charles Stevenson. I represent Jose Delacruz. Until yesterday, I thought we had an issue that was somewhat novel and might particularly catch the court's attention, but I realize now that over the last 4 months, the five of you have been deliberating on the very same issue, and yesterday released a case decision in Commonwealth versus Pena, which in many respects mirrors the first of the issues that I raise on Mr. Delacruz's behalf, and that is our assertion that he was prevented from retaining the counsel of his choosing for reasons that were inadequate and in a manner that was procedurally deficient.
Well, you really think they're the same?
No. I mean, I think they raise the same essential issue, the Sixth Amendment right to retain counsel. I take no issue with any of the court's analysis in the Pena case. I think, in fact, it's in many respects yin and yang of this case because of the circumstances here in contradistinction to the ones that were presented in Pena. Just to remind the court of some of the general observations you made, that a judge is entitled to give due weight to matters of scheduling in determining whether someone should be afforded a continuance in order to retain counsel, that there should, however, be no myopic insistence on haste. Third, that there should be a fair opportunity to secure counsel. Fourth, that dilatory tactics on the part of a defendant are an important consideration, impliedly gaming the system. And finally, that there is no mechanical test. Most important, I think, of all, it's an all the facts and circumstances sort of inquiry. In this case, and I guess it also bears repetition, that the court considers the governing standard to be a, quote, patent abuse of discretion. Patent, palpable. It's a significant burden that the defendant shoulders in these circumstances. But I would submit, and really with no equivocation, that in this case, Mr. Delacruz has demonstrated that, in fact, the judge's discretion was abused. A failure to listen, a failure to balance the respective rights and interests, and a complete, utter failure to explain why he did what he did.
I have to say, it's reading these transcripts, it's almost like there's a missing conversation here.
I suppose I've scratched my head a bit about that, too. And one of the cases that I sent in a 16L letter a few weeks ago, and one of them addresses it because there's this implied suggestion, well, this girl, it was a young woman whose father was out supposedly on the market looking for a lawyer, she didn't have any money. How could she have retained a lawyer? And, of course, Mr. Delacruz was languishing in Charles Street, and clearly he had no money either. It was a family issue. But in any event, the upshot of the case is that there, in fact, had been this conversation back in the lobby, off the record, to the effect that, hey, you know what, I didn't get any money. And then they come out and go through this process. Well, and the court says that is completely, totally, utterly improper and no grounds for justifying what the judge did. Not surprisingly, the four cases that I cited all involve findings that trial judges, whether at the state, and a couple of them are habeas corpus cases, and that's not an easy burden to meet these days, whether state or federal judges had abused their discretion.
But was this the first time Judge Gaziano picked up that file?
He first picked it up, as far as we know,
Yeah.
on March 3rd. And on March 3rd, the only subjects of conversation were, do we do this in July or do we do it in November? The judge said, well, I guess he mentioned August too, and the prosecutor.
But at that time, that May date was set. It had been set earlier than that.
It had been set in November. So at that point, presumptively, it was going to be May 2009. But there was never even mention of May that day, when, you know, there actually were a fair number of participants there, though, of course, Mr. Delacruz wasn't present, but at least his lawyer was there, his lawyer then assigned, as well as the putatively retained lawyer. But in any event, I mean, you know, the government didn't say, hey, we got to do this in May. No more continuances. We've got somebody coming in from California or any of those sorts of things that might justify saying, gee, we got an issue here. Absolutely. I mean, the judge says it's in the supplementary appendix on page 27 and 28. I mean, his reason for July is not a great one. When Mr. Halal, I guess is the way you pronounce it, the prosecutor said, well, we could do November. He says, well, I'd rather not, Mr. Halal, because I need to put some cases into July, and this is a case. Then judge says, we'll tentatively say July 13th, and then he closes the hearing. Well, why don't we come back Thursday and give you today and tomorrow to break down the July date, after having said, well, you know what, we really ought to have the defendant here to make sure that this is what he wants. Then a week later, there's a docket entry, page A12 in the appendix, and I think it's Lane versus Commonwealth. I've forgotten who versus the Commonwealth. Entries in the clerk's docket are prima facie evidence of what occurred. Well, at that March 3rd hearing, there was an entry made, trial to be either the 12th or the 13th or 20th of July. So, you know what? There it was. But then the clerk sort of seized control of the proceedings on the next date, a week later, and says, we've got a presumptive date of May 12th.
Did anyone say, hey, wait a minute, the judge said July, and now where'd this May date come from?
Mr. Delacruz's lawyer wasn't there. I mean...
Oh, Mr. Galliboy was there.
Pardon me?
Wasn't Mr. Galliboy there?
Yeah, but, you know, he wasn't his lawyer at that point.
No, I understand that, but he didn't actually say anything, right? When the judge said, we're going to do this May 9th, he said, okay, Your Honor.
Yeah, he said, okay.
I mean, I'm not saying, I appreciate that he wasn't his lawyer. I'm not trying to say that that binds the defendant, but it was just another piece, as Justice Corey said, of is something else going on here?
Yeah, I mean, he did explain. I mean, first clerk, then Mr. Galliboy saying, geez, you know, I want to do this, but it's on a provisionally. I can't do it in May. And the judge just says, well, it's May 12th, and Mr. Galliboy says, okay. And then, and I point out, you know, you know how stenographers now put start and stop times in their transcripts. A 4-minute hearing, at least a minute of which at the end has the judge and Mr. Galliboy talking about a couple other cases. I mean, it's really very disturbing. And you know, I think that if there were one thing that you could lay at Mr. Delacruz's feet by way of blame, it would be, you know, his family didn't get this deal done back in July or August or September of the year before. But, you know, again, citing to the record appendix, page 3, his address is Magnolia Street in Dorchester. It isn't Mount Vernon Place on Beacon Hill. I mean, you know, there are, after all, some practical problems that a lot of people encounter when the necessity is there to come up with a huge retainer to hire a lawyer. So, and you know, it's not as if the government said, geez, you know, why is this happening? They simply stood by, and you know, I can understand their frustration now. I mean, I would certainly share it. But nonetheless, you know, it has every indicia of an abuse of discretion.
You say that that this is structural error? Is that what you?
Oh, I really don't claim to say that myself. I am relying on the Supreme Court of the United States, which, and you know what, they had the debate, and it was heated, and it was, as often is the case, 5-4. But you know, and I tried to think, I mean, the logic of the court is, hey, you know what, this is not a right to a fair trial. This is a right to a particular guarantee of a fair trial, which is to hire the lawyer who you want to have. And you know, the dissenters were, you know, hot and heavy in response, and strong medicine. And you know what? It is strong medicine. But, you know, they had that debate, and I think it's binding on all of us here. And you know, it makes sense, too. I mean, remember when Jim Baker got parachuted into Florida the day after the election, and you know, what if it had been I don't know, Ted Olson, or you know, he had a particular set of skills that he brought to that next month and a half down there, and you know, we see what I mean, would there have been Iraq? Would there have been Abu Ghraib? Who knows? Maybe so. But, you know, and to give you a main example that I thought of, too, there's a fellow named Joshua Chamberlain, once the president of Bowdoin College, but a second lieutenant in the Union Army who held, it's called Little Round Top. It was absolutely, without question, the pivotal moment of the Civil War. If the South had, you know, would Maryland be a slave-holding state now? You know, it truly was, and maybe, you know, maybe any lieutenant would have done that.
Well, I mean, there are also some practical considerations. I mean, what if this case had been continued a number of times? What happened if the judge bought into that, and come along July, the trial lawyer said, I need a continuance. Just give me another month. And the judge said no, and the guy's not ready.
Well, I'd have a really tough argument. I might still be trying to make it. But the fact is that he had said on March 3rd, I can be ready. And he said it again on March 10th. And you know, it just, I mean, I'm not very good at hypotheticals, but you know,
can't get out of it that easy.
that one doesn't strike me as a particularly great argument for me if I would be here saying it should not have happened in July after counsel had been retained and had said, I can do it then. So, you know, it really, it is strong medicine, and
what do we do with, I mean, what's funny about this case is that if when it was first presented by Galibois, if the judge had said on March 3rd, no, this case is already 2 years old, it's already had a substantial continuance because we've already had new counsel, May is the date, either be ready for May or no, you would still be arguing, but with much less force. What is the consequence of the judge's apparent willingness to have that flexibility and then to withdraw that flexibility? What do we do with that?
I'm not sure what I do with it, and I don't have a whole lot of suggestions to the court, except to say that, you know, it's not just defendants whose words and actions can cause people to draw reasonable inferences about their intent. And, it sort of looks like a duck and quacks like a duck kind of thing. I mean, yes, he could have said that then, and they could have then been debating, well, geez, this enlargement was for this reason, this was for that one. I'm not, Your Honors know Suffolk County an awful lot better than I do, but I don't think this is like totally extraordinary for a case to be roughly this old, and nobody really complaining about it. It just seems to happen. And Rule 36 seems to be at times honored more in the breach than in following. But nonetheless, it just, they never had a chance to say, but gee.
But just to further Justice Gantz's hypothetical, sorry about the hypotheticals, if the lawyer, as he did, came in on March 10th, and the defendant was brought in on March 10th, and the judge had said, I thought about our conversation last week. I really have taken a closer look at the progress of this case. I'm really not inclined at this point to continue it beyond March 12th, or May 12th, excuse me. Would that have been enough sort of deliberation to sort of make it work?
It certainly would have suggested he'd been thinking that, as I said, he'd been balancing things as opposed to being arbitrary. Maybe the record is in some respect misleading. I can't see where it is. These were hearings in open court. This is what happened. I want to very briefly, if I might, just mention that there was a last-ditch chance to correct the problem on the first day of trial. And, it brings a couple of points to the fore. One of them is that Mr. Delacruz is really functionally unable to express himself. Your Honors will see that in reading what he had to say about his assigned counsel. But, what do you say as a defendant facing a life imprisonment trial when the judge says, geez, I hear there's a video. I don't know what defense you could have to this charge. Maybe it's something we would all think, but you know what? We wouldn't say it. And I don't think it helps the government's position that when there was this last opportunity to try to correct the problem, that was the kind of attitude that was.
Wouldn't you agree, though? Putting the unfortunate words to one side, the meat of your argument is on the March 3rd, March 10th problem. Because once you're at the trial date, that's very hard to justify switching gears at that point.
It's not just the meat, it's the potatoes and
the gravy.
It's maybe ketchup on the 12th of May. I did very, very, very briefly want to mention the third argument, which pertains to a supplementary instruction. And, I freely admit here I'm sailing against the wind. That's happened before.
Say it's not so, Mr. Stevens.
And frankly, also, it may be completely and utterly harmless because I'm addressing one of the theories of murder upon which Mr. Delacruz was convicted, and the other is not raised in the same circumstances. But, sometimes I only get a nod or, things don't find their way into an opinion. But I know that the court listens and values the input. And that's this, that jurors, they have to be 18, they have to speak English, they have to be from the county, but nobody gives them a test on how to write a good question, as foreperson or otherwise. And they said, explain extreme atrocity and cruelty. And, one of the debates we've had on occasion is about evidentiary factors and the 6 considerations that jurors have to evaluate in reaching that decision. But you know what? Here, mental impairment was a legitimate and the only, absolutely only issue that Mr. Delacruz was bringing to the jury. And I don't think that sort of the lowest common denominator, well, they didn't ask for, can you tell us about mental impairment again? It's every bit as much an evidentiary consideration, an evidentiary factor, as are those 6 elements. And I would just ask the Court to consider saying so. So on Mr. Delacruz's behalf, thank you for your attention.
Good afternoon, Your Honors. May it please the Court, Chris Foster for the Commonwealth. With me is the trial prosecutor, Assistant District Attorney Amy Galatas. Just to address the defendant's first issue, I think he's already addressed the fact that this is essentially a balancing test for the trial judge, or in this case, the motion judge, but the defendant doesn't have the right to retain counsel of his choice if it's going to interfere with the
So
court.
what was the balancing test that the judge performed on March 10th?
I will agree that it's not on the record, but, well, he didn't state on the record, but I think we can look at just the facts we have from the record. The fact that May 2009, the final trial date, that marks the 2-year mark since the defendant's arraignment, meaning he had been held in custody without trial for 2 years on what amounts to a very simple and straightforward case, considering the defendant was on videotape murdering Tyrese Brown.
Well, surely that's the reason why the judge wanted the defendant to be present when, before deciding that we're going to continue this until July to let your counsel come in. And is that okay? I mean, that's certainly a good reason why the judge would want to have that confirmation. But
it is, but I think that's just one factor. Also, another factor is every substantive motion, including the motions to suppress, had been ruled on by July 2008 in preparation for that original trial in July 2008. So by May 2009, it would be 10 months since anything substantive had happened in this case, and the defendant would still be incarcerated without facing trial. So if you ask for another, if the court, or if the defendant asked for another 2 months, that would have been over at least a year since anything substantive had happened in this case. And several of the cases my brother cites in his 16L letter, in those cases, the defendant was trying to discharge his counsel and bring new counsel in, and new counsel represented that the former counsel hadn't done enough investigatory work, that something was lacking in the investigation, so he needed more time to go forward investigating. Where here, the defense counsel was merely asking for a continuance because the trial date conflicted with his other cases, which I don't think is significant enough. And also, if you look at the docket, for May 13th, March 13th, so 3 days after this last hearing, the Commonwealth requested copies of official transcripts from the suppression hearing, and Judge Gaziano allowed that, but gave the caveat that no more continuances were going to happen in this case. So this wasn't something that he just did to Judge Gaziano just did to the defendant. It was also, he was saying it was time to move the case forward.
So then why did he say what he said on March 3rd?
The record is what it is. Perhaps he did do more reflecting and realize that the defendant had been held without trial since May of 2007. That's a possibility. But other than that, all I can speak for is the record. So I will admit he didn't really articulate several reasons on the record, but if we have here weighing doing this balancing test, on the other hand, July 16th, 2008, this was 2 weeks before the defendant's July 2008 trial date, where he indicated to Judge Healy that he was in talks with private counsel about retaining him. Judge Healy advised him, you can hire whoever you want, that's not a problem, but whoever you hire doesn't have the right to dictate the court's calendar. And then the defendant, knowing that being in talks with counsel since at least July 2008, and knowing getting a continuance wouldn't be allowed just to hire counsel at the last minute, he waits 8 months from that date, 7 months since the trial date was scheduled.
All of that, the problem with all of that is the fact that Judge Gaziano on March 3rd said, yes, we can put it into July. I mean, so all of that's true, and if that had been the reason that Judge Gaziano had said on March 3rd, we can't. This has to go. It's been all the reasons you said. They would probably, it would be very, very, very hard to argue an abuse of discretion. But if you've got the judge saying, no, we can do this in July, and then a week later saying, nope, without a reason. There is a disconnect there that's hard to justify.
I think the March 3rd hearing was also just a tentative date. Again, there's nothing from the record, and it's the defendant's burden to show that there was an abuse of discretion. And just from the record we have before us, this is a defendant who had waited several months to retain counsel despite knowing the trial date. And
Well, money is an issue with retaining counsel.
Right, but the right to counsel of one's choice can also be waived if a defendant has a right to counsel to hire one in a reasonable time. I think here, 8 months had elapsed since he was advised he couldn't dictate the trial schedule, and then waited at least 7 months since this new trial date was set until only 2 months, then bringing in an attorney who already had a conflict with this date. So I think the fact that on March 3rd, Judge Gaziano indicated that the July might work, I don't think that really affects the balancing test.
There wasn't a 211-3 petition in this case, was there?
Not that I have seen on the record, no.
When counsel couldn't go forward?
Yeah. After Judge Gaziano said, no, it's going to go ahead.
There was no 211-3, and the defense counsel at that time, appointed counsel attorney Griffin, did ultimately try the case. And he announced he was prepared all along, including the morning of trial. To briefly address the defendant's third issue.
I'm sorry, I should know this and I don't.
course.
What were the actual questions of the jury?
There were several
Right.
questions.
This was answering to one of them, right? The second one or something?
Yes,
Is
this
that right?
was the question asking to explain extreme atrocity and cruelty. The jury also asked to explain the difference between first-degree murder and second-degree murder. They asked if they were allowed to debate the laws or if they had to take them as they were read to them, and also if there was some type of gray area in the law that they could work with. So what we have here, every single instruction that Judge Spurlock gave, the parties, including defense counsel, thought were proper. So, of course, we're just looking at substantial likelihood here. And there was no requirement to re-instruct on mental impairment. We had a jury that was asking very specific honed questions where they had narrowed their inquiry, where Judge Spurlock was properly just responding to their questions. And this is something where the jury isn't going to forget that the defense is mental impairment. This was what was the issue at trial. The defendant conceded that he had murdered the victim, but only was requesting second-degree murder instead of first-degree murder. So this was in his opening. This was his witness that he called on his defense, and this was his closing argument. So not getting re-instructed on mental impairment didn't mean that the jury forgot that this was an issue. And this was also a jury that wasn't afraid to ask questions. They asked several questions that showed they were really debating the law and the differences between first and second degree. But once they got this instruction, they never asked for a follow-up question, which I think would indicate that they didn't need re-instruction on mental impairment. And again, Judge Spurlock's original instruction on mental impairment was correct and adequate, which I think the defendant agrees with.
Was it in connection? I haven't read it, but was it in connection with? Was it freestanding, or was it in connection with one or both of the murders?
The order of it was first-degree murder, mental impairment, second-degree murder.
And when he answered the question about the difference between first and second-degree murder, which is not the one that's raised here, I don't think.
Correct.
But anything, obviously, nothing about mental impairment there, or was there?
No, and all the parties were content with the re-instruction.
Did the judge specifically tell the jury that they may consider mental impairment in considering whether there was extreme atrocity or cruelty?
I believe he did. I would have to double-check on that, though. And I am aware of the court's opinion last year where it does matter. I will have to check on that. I can inform the court. If there are no further questions, the Commonwealth will rest on its brief.
All right, thank you.